leave to mention and assign writ petition. One of the issue which arises for consideration is whether the Chief Judge City Sessions Court could have transferred, my lord, these PMLA cases from one special court to the other, and whether such transfer is valid or not. The matter has been assigned because there are orders passed by your lordship in a Rose Valley group of matters, and if your lordship kindly takes it up on any day, subject to lordship's
When the Rose Valley matters come, it will be listed.
some, some. We are handing up the slip, my lord. We have also annexed all the orders. Grateful.
Call the list. Please, my lord. But the issue falls for consideration as to whether, my lord, an appellate tribunal can provide a fresh period of disposal, my lord, while remanding a matter back by setting aside the order of confirmation. If I may request your lordship, my lord, to see section, my lord, 26, my lord.
Complaints have been filed.
Complaints have been filed.
In this case, complaint has
No.
been
Well, at least not to our instruction.
complaint has been filed.
Complaint, yes.
Criminal
Yes. There he got bail.
Criminal complaint has been filed.
Yes.
All.
He got bail. He paid for cancellation of.
All. Yes.
Now, my lord, according to subsection 1, my lord, any order passed by the adjudicating authority, my lord, is appealable. According to, my lord, subsection 1 of section 26. Now, my lord, if I may just request your lordships to see, my lord, subsection 4. My lord, according to that, my lord, according to that particular enactment, an appellate tribunal has jurisdiction or authority to pass 3 types of orders, my lord. It may either confirm the impugned order, modify, or set aside.
Last option, your lordship absolutely find out the judgment.
Sir.
Now, my lord, if your apropos this, if your lordship sees, my lord, section 8, well, I'm sorry, I'm taking your lordships in a reverse direction, then I'll just place, my lord, section 5 after 8. Now, my lord, if your lordship sees 8 talks of, my lord, the process of adjudication, where, my lord, a complaint has to be filed within 30 days from the date of, my lord, pro tem, my lord, that attachment. Now, once that complaint is filed, my lord, according to 8.1, there will be a notification, my lord, to the aggrieved person, my lord. As to why, my lord, it will not be declared to be the proceeds of crime. Now, as for subsection 2, my lord, once a reply is filed, if any, my lord, or at least opportunity is granted, my lord, then the authority has, my lord, has to come to a finding, my lord, after hearing both the parties. It has to record a finding to that effect, A. B, my lord, it has to confirm the attachment, and as a consequential relief thereof, my lord, the director may proceed to take possession of the property. So, my lord, there are 3 or 4 intricate steps mentioned in, my lord, section 8. Now, my lord, 8 can be triggered in only, my lord, in case, my lord, a section 5 action was undertaken. Now, let's see the beauty. Section 5 action can be undertaken provided two contingencies are satisfied. A, my lord, that prima facie there has to be, my lord, a satisfaction to the effect, my lord, that there is prima facie case of possession of proceeds of crime, and number two, my lord, imminent threat or chance of concealment. Now, my lord, kindly conceptualize a case where, despite, my lord, a complaint filed under 44 before the criminal case, there may not be imminent chance of dispossession or, my lord, concealment. In that case also, my lord, there cannot be a proceeding under section 5. And if there is no 5 proceeding, my lord, there cannot be 8. But at the end of the trial, my lord, there can be an order, my lord, under section 8, subsection 5 by the court for attachment of the property, my lord. Now, my lord, the point which I want to make before your lordship, my lord, that the adjudication proceeding is not mere confirmation of that, my lord, something beyond that. No matter what happens if the time expires, there are two things, my lord. My lord, this timeline envisaged under section 5 as such, my lord, not in 8, in 5, was considered to be, my lord, in-house safeguard, my lord, in Vijay Madan Lal. Now, my lord, it was held to be not extendable under any circumstance. Now, my lord, therefore, my lord, if we connect all these dots, therefore, my lord, when the order is set aside by the appellate tribunal, my lord, there will be no revival of, my lord, the time period. Reason being, my lord, once the final order is set aside, then the interim order must have been merged with the final order, so that also dies.
What is the impact of interim attachment?
My lord, that's a symbolic possession is taken, nothing else, my lord. It's a temporary pro te management, my lord.
Where is the impact stated?
My lord, if your lordship will kindly see, my lord, subsection 1 of section 5, my lord. That's the conditions as such, my lord. And thereafter, he may, by after those conditions were satisfied, my lord, kindly says he may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order, as such manner as may be prescribed. Thereafter, my lord, what are the other conditions prescribed? And again, my lord, subsection 3 reiterates that period.
What is the other condition? No such attachment shall be made.
But there has to be a complaint filed or a police report on board, my lord.
There must be a police report or a complaint filed in respect of the scheduled document.
Right. And there has been another exception to that also, my lord.
In your case was a complaint.
Complaint was filed, my lord.
Which
That
complaint?
police, that's a charge sheet filed, my lord.
Under
PC Act, my lord. And also Indian Penal Code of Ethics.
under PCO. When the interim
My lord, it's there, my lord. So there is no violation of this.
no
My lord, I'm sorry, my lord. My apologies. The charge sheet was filed under 420, 406, 120B. These three,
All right.
not PC Act.
and there was a provisional attachment. Now, what is the consequence of a provision?
But the only symbolic possession, my lord, is taken, and what happens?
Where is it stated?
My lord, if you, my lord, there is nothing as such in section 5 subject to correction. If your lordship sees, my lord, section 8 subsection 4.
Section 5, subsection 4, probably your lordship.
It's only the prevention so far the enjoyment of the property.
Now, what is the meaning of enjoyment?
Well, these
Can he create a lease? Can he mortgage? Will it block a transfer?
well, there will be no, at the most, well, there will be no third party interest created, because
Third
that
party.
was, my lord, The way it was interpreted in Vijay Madanlal.
Where is we are being cited Vijay Madanlal, Vijay
Well, if I may
Madanlal. Where are these observations of Vijay Madanlal?
May I just request?
What is the impact of an injury? Or what?
Even under final, after final order, my lord,
Then we'll cross that bridge later. We want to see what is the impact of a provisional attachment. Provisional attachment, does it what does it clog? It doesn't clog enjoyment, right? What the law says that we are not going to clog the enjoyment of the person interest. Now, what is enjoyment? It will stop a transfer.
it will not, my lord,
It will not.
because nothing in this section shall prevent
Correct. Shall prevent what?
the enjoyment of the in relation
Right.
to the
Now,
immovable
will
property.
enjoyment include transfer?
My lord, enjoyment is a generic term. If you're not-
generic term restricted to person interest.
Right, my lord.
Will the person interested be empowered to transfer enjoyment to a third party?
Well, since there is no legal inhibition to that effect,
It's
therefore,
not a question of legal inhibition, it's a question of legal restriction.
right,
You can only enjoy.
it's not that
So you-
specific, my lord, that it's
Wait.
only so far that I am concerned.
Says
My lord, then
person
it would have been that it, my lord, the
Shall
subsection,
prevent the person interested in the enjoyment. Nothing in this shall prevent the person from such enjoyment. So the enjoyment is of the person interested, and therefore, in our understanding, we may interpret transfer inter vivos is stopped. That is, in other words, enjoyment cannot be in any one else's hand, or enjoyment cannot be transferred in respect of the property to another juristic person or natural person. So any transfer envisaged under the Transfer of Property Act, Sales of Good Act is stopped.
well, apropos that, my respectful submission will be, my lord, the word person is qualified by the word, my lord, interested.
Yes, so
It's not only the claimant, my lord, the person interested.
the person interested is perhaps defined in the Act.
Now the next explanation,
Yes.
just
Next.
after that.
Yes, please see.
All persons, my lord, claiming or entitled to claim any interest in the said property.
At the time when the attachment is.
Right, my lord.
So nobody, a third party will be created to claim to be a person interested post-attachment. That is what we are saying, that it would create a clog on the transfer of the property. When the provisional attachment is in force, you would argue that provisional attachment having expired by lapse of time, it would not stand in the way of the adjudicating authority coming to a finding with regard to proceeds of crime under 8.2, but in that interregnum, the provisional attachment will not continue. That's your argument.
But kindly see subsection 4 of section 8 once, my lord, apropos this. What happens, my lord, even after, my lord, confirmation,
Your chair is uncomfortable. Then why are you standing?
As to assist your lordship.
Don't assist. We are engaged with someone.
my lord, kindly see subsection 4, what happens, what is the consequence, my lord, after the order being confirmed. Then according to the section, my
It
lord,
continues for 365 days.
or my lord, till disposal of the trial.
If investigation goes on, it continues for 365 days. And if in the interregnum a complaint, a charge sheet is filed, it continues
Till the
the
trial.
end of the case. And the other consequence is your enjoyment ends, they take physical possession.
My lord, that is only in exceptional cases, my lord, the way it was interpreted, my lord. Which is why, my lord, kindly see subsection 4. If we go literally, then, my lord, what has fallen from your lordship? 8.4, my lord, subject to correction.
Shall forthwith take the possession. So possession is to it, provided if it is not practicable of a property frozen or of, shall have the trigger as if it is been taken.
My lord, apropos this, kindly see paragraph 179, my lord, from Vijay Madanpan. Because literally, my lord, it says, my lord, immediate effect is, my lord, the possession will be taken. My lord, para 179. I hope, my lord, it will match because this is from regular SCC now. 179, my lord, will start with the expression the other grievance of the petitioners. 179, 180. Up to 183.
Okay,
Now, if
understood.
that is the situation, my lord, after confirmation, then in the
So what we'll do is,
but I have
it will be remanded. It will be remanded. We will record your submission that the provisional attachment has come to an end. However, the remand being to consider whether the property is subject to proceeds of crime or not, till the finding is recorded and any order of attachment is passed, there shall be an injunction upon you not to create any third one.
but that is not there because subsection 4 will never operate, my lord. I go back to the stage of, my lord, subsection 4 of section 5.
Subsection 4 will always operate once.
That will always operate, and that will give me, my lord, carte blanche to enjoy the property, my lord.
You will enjoy the property, but you will not transfer the property.
But enjoyment will include transfer as
No,
well.
sir. Under the provisional attachment, it will not, and therefore, when we remand it, we will injunct.
But your lordship has seen that paragraph, my lord. Kindly, if I may just request your lordship to see once more, my lord. Kindly sees, my lord, para 179. Kindly sees, my lord, para 180, my lord, after placitum G, the civil consequences, my lord, as conceptualized. In the interactum, if there is any change, my lord, transfer. Para 180, my lord, after placitum G.
Read out.
But if I may place, my lord, once the possession of the property is taken in subsection 4 and the finding in favor of the person is rendered by the special court thereafter and during interregnum, if the property changes hands and the title vests in some third party, it would result in civil consequences even to the third party. That is certainly avoidable unless an absolute necessary in the peculiar circumstances of the particular case so as to invoke the option available.
This is against you. That we should.
But that your lordship is right, but that is when order is confirmed.
Correct. So, in a contemplation that the order may be confirmed, we cannot endanger interest of third parties who may be persuaded by you to obtain interest in the property and thereby would lose their valuable consideration.
But I need to disclose only. It
We
will
are
be
not
an
concerned
encumbrance
about that.
at the best, my
We
lord.
are not concerned about.
No,
It's
but
a question of balance.
right, but that's not the issue exactly. My lord, what was my primary submission before your lordship, my lord? Section 26, subsection 4, which envisages, my lord, what are the options available with the learned appellate tribunal. Well, it was either it has to confirm the order, modify, or set aside.
So,
Cannot remand.
you are going back to that argument.
Well, that's dangerous, my lord.
Very-
I have authorities, my lord, in this.
Oh,
Subject to correction by your lordship, my lord, the exact, perhaps, my lord, subject to correction by your lordships and my learned friend, my lord, there is no authority interpreting subsection 4, my lord, again subject to correction, at least in SCC, my lord, I've tried. My lord, I am armed with 2 judgments of Honorable Bombay High Court, my lord, not on PMLA, in other proceedings where, my lord, the powers were, my lord, akin. My lord, the first one is, my lord, Sakil Abdul, 2019, SCC Online, Bombay 2604. But your lordship will give me a moment's time. And relying on that, my lord, is subsequent judgment also. And my lord, one judgment of the Honorable Supreme Court on the power of tribunal, my lord, my lord, the inherent power. If your lordship sees, my lord, only paragraph 33. But it was, my lord, in connection with debt recovery tribunal, my lord. If I may just request your lordship to come to paragraph 33, my lord, which will be at page, my lord, 356. But in case of appellate tribunal, even there is no similar provision. Subject to correction, my lord. What? Just I have read, my lord. Therefore, my lord, the learned appellate tribunal, my lord, being a creation of statute, has to go strictly by the letters of statute. And remand, my lord, is not a necessary power, my lord, of an appellate tribunal. And a tribunal is not a court, may have all the trappings of a court, my lord. Therefore, my lord, the very order of remand is bad in the eye of law. Since there is, my lord, issue of procedural fairness, non-observance of procedural fairness, my lord, the learned appellate tribunal should have, what learned appellate tribunal has done correctly, my lord, set aside the order, but should not have remanded the matter. My lord, that's my submission, my lord. Most of it.
Yes.
And on the last occasion, your lordship asked me to find out whether there is any authority saying that this power under subsection 4 to modify, confirming, or setting aside includes the power of remand. But I have tried my level best and I have found this short judgment of this honorable court. This is reported in 1998, 98 ELT 584 Supreme Court. But paragraph 2, as the order under appeal itself notes, the aforesaid provision vested the appellate authority with power to pass such order as it deemed fit, confirming, modifying, or annulling the decision appealed against. An order of remand necessarily annuls the decision which is under appeal before the appellate authority. The appellate authority is also invested with the power to pass such order as it deems fit. Both this portion of the aforesaid provision read together necessarily imply that the appellate authority has the power to set aside the decision which is under appeal before it and to remand the matter to the authority below for fresh decision. But this was under Customs Act. Now, my lord, another judgment I'll be relying the Honorable High Court Madras. My lord will kindly pardon me. This is of Honorable Single Bench of the Honorable High Court Madras, my lord. Para 2, para 2. Same, same, identical. Para 2. My lord, this, my lord will kindly take from paragraph 17, page 3. Is Babu or copy नहीं रखना? Is Babu. My lord, para 17, His Lordship has referred to the Central Excise Act, provision of 35A. Kindly see subsection 3. The Commissioner Appeal shall, after making such further inquiry as may be necessary, pass such order as he thinks fit, thinks just and proper, confirming, modifying, or annulling the decision or order appealed against. Then, my lord will kindly skip some part, 35C, order of the tribunal, appellate tribunal. Subsection 1. The appellate tribunal may, after giving the parties to the appeal an opportunity of being heard, pass such order thereon as it thinks fit, confirming, modifying, or annulling the decision or order. Correct, my lord? Now, my lord, will kindly skip those part and come to paragraph 20. Next page. Though at the first blush, the arguments advanced by the learned counsel for the petitioner appears to be impressive, but on a closer observation, it proves otherwise. In my considered view, subsection 5 does not specifically state the provision of section 35A of the Central Excise Act has to be read into the provisions of the Finance Act. In fact, section 83 of the Finance Act enumerates that the sections under the Central Excise Act 1944, which would apply to the matters relating to the service tax, and it does not include section 35A of Central Excise Act. This is clear indication that the said provision cannot be superimposed into section 85 of Finance Act. Assuming, for the sake of argument, that the contentions advanced by the learned counsel for the petitioner is sustainable, subsection 5 of section 85 only speaks about the procedure to be followed while hearing the appeal and making orders, and the procedures to be followed under the Central Excise Act. Thus, subsection 3 of section 35A of Central Excise Act cannot be superimposed into subsection 5 of section 85 of the Finance Act. What is crucial to note is that subsection 4 of section 85 provides the manner in which commissioner appeal shall hear and determine an appeal, and it only states that he can pass orders as he thinks deems fit. The provision is in perimeteria to section 128(2) of the Custom Act, which was considered by the Honorable Supreme Court in Union of India versus Umesh Dhaimodi Supra, and it was held that the said provision would include the power to remand. Therefore, the argument advanced by the learned counsel for the petitioner by reading into subsection 5 of section 85 the provisions of section 35A3 is an incorrect interpretation. Further, my lord, I am skipping Gujarat High Court, then kindly come to 23 para. In view of the above reasons, I have no hesitation to hold that the first respondent, while exercising powers under section 85(4) of Finance Act, has power to pass orders as he thinks fit, and such orders will also include an order of remand and amended to section 35A3 with effect from 11/5/2001 does not in any manner impact the power of commissioners of Central Excise Appeals while dealing with an order passed under the Finance Act. Hence, the contention raised by the petitioner has to be necessarily failed, and the same stands rejected. So, my lord, these two judgments on this authority, and my submission would be that the power under section 26(4) is including the power of remand. Now, coming to the second part, my lord, the judgment, only one thing I will show. The judgment referred of Standard Chartered Bank by my learned friend senior, my lord, paragraph 33. My lord, will find there their lordship had referred to section 19, subsection 25. Paragraph 33. My lord, will kindly see the tribunal may make such orders and give such directions as may be necessary or expedient to give effect to its order. My lord, that was a power of execution of the tribunal. So that is not with respect to the appeal. It's a power of execution. How to prevent it. Now the second part, what my learned friend was saying, my lord, what following from your lordship, my lord will kindly take that purpose of provisional attachment your lordships were asking. Then what is the purpose of provisional attachment? I referred to the subsection 4, that enjoyment part, and the explanation thereto. My lord will kindly also consider section 5, subsection 1, and clause B thereof. The purpose of provisional attachment is mentioned here. That such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceeding relating to confiscation of such proceeds of crime under this chapter, he may order in writing provisionally attached. So,
Do you read the two provisos in conjunction or as alternate to one another?
I'm not on proviso. I am in conjunction, because the word is used and clause A and clause B is in conjunction. Subsection 1, clause A and clause B.
No, sir. Please read the second proviso. It
Proviso,
opens with the non-obstantive rules.
but proviso, my lord, is referring to.
Second
Second
proviso to subsection 1.
Correct, coming, my lord. Provided, this is non-obstantive. Provided further that notwithstanding containing first proviso, my lord, I was not referring to first proviso. Anyway, first proviso, any property of any person may be attached under this section if the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section has reasons to believe. The reasons for such belief is to be recorded in writing on the basis of material in its possession that if such property involved in money laundering is not attached immediately under this chapter, the non-attachment of the property is likely to frustrate any proceeding under this act.
Right.
Well, this is in reference to clause B.
Huh.
That is what I am saying. So the enjoyment at subsection 4 is
No, where are you reading that there is a chance of concealment of the
well, clause B I am referring. Subsection 1, clause B. The purpose of provisional
and
act.
it is likely to be concealed.
Yes. But that is what I am saying, that subsection 4, the word enjoyment, what your lordship was fallen from your lordship, I bow down to that. Is that only enjoyment of the person who is in possession of that property for that moment? Nothing else. Because the purpose is to stop alienation. And
We are upholding the order of remand, will pass an injunction till the remand is passed. There shall be no third party interest.
this is already there, my lord, and your lordship expressed your lordship's mind
Yes.
to provide a limited period of
Yes,
time.
we'll say within 1 month it shall.
My lord, kindly, may I pray for 3 months, my lord?
Yes, Mr. Bhatt.
Because natural justice
Madam,
to be
so far the Supreme Court's judgment is concerned, madam, the statute was differently worded.
safe.
Because if I may just see place para 2, madam, it was mentioned that an order of remand necessarily, madam, that's the observation. Sees the appellate authority is also invested with the power to pass such order as it deems fit. Madam, in case of PMLA tribunal, madam, that part is also there, but that is couched with, my lord, these 3 contingencies, either to confirm or to annul or to modify.
Here also,
It was not an independent clause. But there are other judgments too, where the terminology, my lord, to pass such order as it deems fit, my lord, occurred in the
Just show us 128(2) of the Customs Act.
but in the new old act which was, my lord, interpreted, and in the new book or in, my lord, not in the Google, my lord, I'm just getting how it was what
128 of the Customs
old
Act.
Customs Act.
That is relevant, and I think it is in the same words because the Madras High Court judgment says that 35
A3,
35A3
3,
has the same words as 128(2) of the provision is in perimeter to section 128(2), and if you see 35A3, it is pass such order as he thinks proper, confirming, modifying, or annulling the decision.
35, পরের পাতায় আছে যেটা জজ সাহেব পড়ছেন।
So it appears, Mr. Bhattacharya, if you read paragraph 17 of the Madras judgment, in conjunction with paragraph 21, his lordship, as his lordship then was, held that 35C is perimeter to section
128(2).
You should have produced 128.
I tender my apology. I should have carried that. I go away with that 135A3 was quoted.
Why should you
Yes, madam,
rely on secondary?
Madam, kindly allow me 5 minutes time. I am I've asked my junior.
It's not there in the new book. That's the difficult. It's not there in the new.
But I have asked for it. I've asked for it. They are bringing it from my chamber.
And so far the disposal time is concerned, my lord, my submission will be, since it was never contemplated in the act, my lord, let it be disposed of in accordance with law.
We'll say
And
as expeditious
As
possible.
expeditiously as possible, my lord.
Because after all, the tribunal is headed by a former chief justice.
And in any case, my lord, learned friend cannot say anything because he is a party there.
We would not, we understand, we will couch it in appropriate terms. We'll couch it in appropriate.
But your lordship will not record. I don't give any consent to anything, my lord.
No question of consent. The 2 issues that you've argued is remand, and let's take the appeal. There's no dealing. There's no dealing. There's no dealing. Take down. The appeal is directed against judgment order dated 9/4 to order dated judgment order dated 9/4/2024, passed by the appellate tribunal under appellate tribunal appellate tribunal setting aside the order of the adjudicating authority, setting aside the order dated what 23/9/22, passed by the adjudicating authority, confirming the provisional attachment order dated 31st March 2022. The short compass on which the appellant assails the order is that the appellate tribunal did not have power enough by the said order. The appellate tribunal set aside the order, the adjudicating authority's order confirming provisional attachment on and remanded the matter before the adjudicating authority. Before the adjudicating authority for fresh consideration. The short compass of challenge is that the adjudicating authority lacks jurisdiction to remand the case for fresh consideration after setting aside order passed by the appellate authority. The order passed by the appellate authority. Section 26, subsection 5, PMLA, inter alia, lays down the power, provides the power of the appellate tribunal as follows. Set out. Good stop. Mr. Bhattacharya contends that the said provision, the provision does not refer to contends that the appellate tribunal is a creature of statute.
Your lordships are right, but I was wrong.
Appellate tribunal is a creature of statute and can exercise powers expressly can only exercise powers conferred to it. A plain reading of the aforesaid provision, the aforesaid provision does not confer the power of remand, full stop, does not confer the power of remand. Per contra, Mr. Chakraborty, na? Mr. Chakraborty contends the words inverted comma, the words may pass such orders থেকে appealed against are of the widest amplitude and would vest powers of remand as consequential to the power to set aside the order appealed against. Good stuff. The aforesaid provision is pari materia to section 128A of the Customs Act, which reads as follows. In Union of India versus Umesh Diamond, the apex court, while interpreting section 121, 129, 128(2) of the Customs Act,
Asked while it was
128(2) of the Customs Act 1962.
What SCC citation I have? Should I give?
What is this?
1997, volume 10 SCC, page 223.
Thank you. Inter alia held that the word inter alia held as follows. Let us set aside. Paragraph 2. Extra. The words powers of the appellate tribunal, the appellate tribunal under PMLA Act is vested with the words used in section 26 subsection 4, vesting powers to the PMLA tribunal, to the appellate tribunal, are in the words used. No, the words used in 26 subsection 4 are similar to that in section 128(2) of the Customs Act 1962. Full stop. The word appellate tribunal was empowered to is empowered to pass such order. Is empowered to pass such order as it would deem fit, was empowered to pass such orders as it thinks fit, including confirming, modifying, or setting aside the order appealed against. The wide amplitude of the expressions used, such orders as it deems fit in inverted comma, and the expression and the other express and the word setting aside clearly infers jurisdiction in the tribunal to remand a matter after setting aside the order appealed against, unless such power is read into the aforesaid provision. The Now, any other interpretation would give rise to a paradoxical situation where the tribunal, after setting aside an order on the ground of procedural defect, as in the present case, that is breach of natural justice, would be rendered powerless to remand and direct fresh consideration on merits. Full stop. In light of the aforesaid discussion, we do not find any reason to interfere with the order impugned. Mr. Bhattacharya strenuously argues that the provision, once the confirmation order, the confirmation order being set aside, the provisional attachment, once the confirmation order is set aside, the provisional attachment is no longer once the confirmation order is set aside, the provisional attachment would not automatically revive. The provisional attachment is limited by is limited. Now, provisional attachment as per section 5(3), has a limited time span and would expire on the and would expire by and would lose its force by a flux of time. Would lose its force by a flux of time. Full stop.
My lordship, can you consider that Kausala relied on the other?
Yes, we are.
So should I hand over copy?
He refers to Kaushalya Infrastructure 2022 SCC Online SC 531. Full stop. In the aforementioned decision, the provisional the provisional attachment order was assailed before the was set aside by the High Court, and High Court. It was contended before the Supreme Court that the adjudication proceeding would adjudicate the adjudication proceeding under section 8(1) would lose its force by would be rendered is rendered ocious as the provisional attachment order had lost its force, negating the argument the apex court held that the adjudication proceeding may continue notwithstanding expiration of the provisional attachment order. The ratio in our considered decision, in fact, in our considered decision, is of little help to the appellant. Even if the provisional attachment order has expired by a flux of is of little help to the appellant. Full stop. Firstly, the challenge before the appellate tribunal was against the confirmation order and not the provisional attachment order. The confirmation order it is nobody's case that the confirmation order has lapsed by a flux of time. Full stop. Has lapsed by a flux of time. Moreover, moreover, has lapsed by a flux of time. Accordingly, the appellate tribunal was justified to set aside the confirmation order and remand the matter for fresh consideration in accordance with law. Good stop. Mr. Chakraborty, a flux of time, full stop. It has been rightly argued, pending adjudication, there is possibility that third party interests may be created and the the purpose and object of restraining transfer or concealment of the property which is contended to be proceeds of crime will be frustrated. In Madan Lal Chaudhary, in Vijay Madan Lal Chaudhary, the apex court the apex court interpreting section 5(4) and 8(4) of the act inter alia held inter alia held that inter alia held till the possession of the property changes till the possession of the property is taken over in terms of section 8(4) of the act, any third party interest, any transfer in favor of third parties creating civil consequences ought to be avoided. Bracket C, paragraph 179, 180. Full stop. In view of the aforesaid proposition of law, and in order to ensure that the adjudication by the adjudication before the adjudicating authority is not frustrated by transfer of the properties in question, we injunct with the appellant from creating any third party interest in the property till the disposal of the proceedings before the adjudicating authority. Needless to mention, the appellants as person interested would be entitled to enjoy the property itself. Full stop. Adjudicating authority is requested to dispose of the adjudication at the earliest without granting unnecessary adjournments to the parties. তুমি একটু শোনো।
Can 8 is that application, my lordship will Can 8 is that application, lordship will remember, my lord, where, my lord, we had sought for, my lord, and my lord, exemption to those properties which do not belong to the director of the company. Now, my lord, this, my lord, from 23 onwards, lordship had passed an order of interim injunction, but, my lord, 23 onwards, they were directed to file affidavits. My lord, they have not been filed by,
Who
my
have
lord,
filed?
the ED as well as by the state. The others have. So, Malad, that can be taken up. Two properties do not belong to the company or to the directors. Rest, Malad, they can.
Even if they have not filed affidavits, whether Mr. Chakraborty, you are appearing?
Yes. Malad,
Please take instructions on these two properties and state
but I've given letters also to them, Malad.
persons, Mr. The two persons who are relevant are the ED and the
Yes.
state.
Yes, Malad.
Please make your responses in respect of these two properties. What, my lord? What, my lord? Why you will take instruction? This matter is pending long.
In এতগুলো ওটাই চিঠি
You have not attached, you have said that these properties belong to the company.
No, it does not belong to the company, Malad, or to the directors.
Mr. Chakraborty, please indicate whether these properties are proceeds of crime. All right.
There are 5, Malad. 2 of them I have said they do not, Malad. Rest they can.
Let us just get a report from them. All right. State shall submit report whether the properties, namely so and so and so and so, belong to the key group of companies.
Malad, FPS.
FPS group of companies and or their director.
Yes.
All right.
Yes.
ED shall also submit report stating whether the properties, the said properties constitute proceeds of. Reports shall be peremptorily filed within 4 weeks.
Malad, matter is fixed on 20th. This matter, Malad, is again
By
returnable.
20th. By 20th. All right. At least let us finish this. If they are not there, private parties should not be disturbed.
Yes.
Hmm.
I can give another to you at a copy charge. I'll give. Grateful, Malad.
There's only one thing, my lord. There is an application taken out by my client, that is CAN 38, regarding reduction of certain price, because we have could not get buyers 7 successive auctions. That needs to be taken up because on
On 20th, we'll take on
20th.
Please give the number on 20th.
Can.
Yes. Next matter,
আমি চলে যাই
6 and 7.
But, with all probability, Munad, this section 7, 6 and 7 is relating to Saroda company, Munad. But the other matter, the Saroda matters, Munad,
We'll
Because-
keep it in monthly list of April.
it is in the monthly list, but in the month of April, your lordship will take up.
Yes, we'll keep it in April.
Well.
Pass an interim order in this connection.
Yes, we-
We are requesting for extension of that interim order.
All right.
Malad, can you allow me to find my exhibit?
you undertake not to transfer the property.
Yes, that was the order also.
All right, interim order extended till third parties, interim order is extended till 31st May 2025. Let this matter appear in the monthly list of April 2020.
Exhibit in opposition fine.
Affidavit in opposition is placed on.
And that will be supplied.
Yes. Yes, next matter.
Keep the best.
In this matter,
Hearing on behalf of the petitioner, like, আমরা petitioner, like, অধিক time হবে, sir, আপনি আসলে ওইটা
Next Thursday. I will. But I will not be the 30th. My lord, on 20th, my lord, 20th. It will take only, or 27th, my lord. My lord, then on 13th, my lord, I will assist your lordship. My junior, 13th.